committees.
And you can have it all with your membership in the Greater Bakersfield Chamber of Commerce.
This is Strictly Business, presented by the Greater Bakersfield Chamber of Commerce. Sponsored in part by the law offices of Young Wooldridge, San Joaquin Community Hospital.
Welcome back to Strictly Business. I'm Nathan Ollie, Manager of Government Affairs at the Greater Bakersfield Chamber of Commerce. And in our Spotlight segment this week, we're going to take a look at some new laws. In 2015, we ushered in several major changes to the labor code that may impact your business. And here to discuss some of those new laws that hit the books just on the 1st of January is Jerry Pearson, partner at the law offices of Young Wooldridge. Good morning, Jerry.
Morning, Nathan.
Thanks for being here.
You're welcome.
So let's talk about, first off, mandatory paid sick leave. So what does this mean?
Yeah, well, we have a lot of new laws taking effect this year in California, and the mandatory sick leave is certainly the one that everybody's talking about. We've kind of seen it coming down the pike for a couple of years, warning employers it's going to happen, and now it has. So mandatory sick leave is in effect for all California employers, regardless of size, and it requires all employers to, if you don't already have a paid sick leave policy for your employees, you're going to be required to do so.
Okay.
So there are two effective dates. As of January 1, which was a few days ago, all employers in California must have a poster to post in their workplaces notifying their employees of their rights to paid sick leave. And they must be sending out a new amended wage theft notice, which will also include in that notice the employee's rights to paid sick leave. And then as of July 1, that's when the paid sick leave actually goes into effect.
Okay.
So on that date, that's when your employees are entitled to get their paid sick leave. And it's for any employee that works more than 30 days for the company. They're entitled to start accruing and taking paid sick leave. And that's going to come in one of two forms. An employer can either start letting their employees accrue sick leave.
Okay.
And that's a bit complicated, but it's 1 hour for every 30 days of 30 hours worked, I'm sorry.
All right.
If you work that out, it'll come out to about 8.5 days per year, okay? And an employee is allowed to accrue that and carry over a certain portion of that sick leave from year to year, and employers can't put caps on that. A simpler way to do that, an employer can also simply give an employee 24 hours or 3 days of sick leave per year. The caveat with that is if you're going to do that lump sum, you have to front load that at the start of the year.
I see.
Okay, so the thinking being by the legislature is they want to make sure that an employee has a certain amount of sick leave at the start of each year to use.
Okay. So what kind of limitations can be placed on the employers if they don't comply?
Limitations if they don't comply?
Or penalties, I suppose.
Penalties if they don't comply. Well, they can be cited.
Okay.
So there are penalties if you don't comply with that. The labor commissioner, as we know here in California, is becoming very vigilant with auditing employers. So if the labor commissioner finds out that an employer is not complying with any wage and hour law, this being one of them, there are penalties, monetary penalties that can be placed on an employer. So we're advising our clients to, if you don't have a policy in place, to get it in place now. You have a few months to figure out what type of sick leave you want to do, whether it's the accrual or whether it's the lump sum. That way it's ready to go, because if you don't have one, you likely will get nailed by the labor commissioner, and there's a monetary penalty there.
Okay. So what other new laws are on the books now that we need to be taking a look at? Well,
there are several. The legislature and Governor Brown were very busy last year putting new laws into place. So a few we should probably hit on. One is AB 1443, which is protection for volunteers and interns. That's effective January 1, so at the start of this year. That amends the Fair Employment and Housing Act, which is discrimination and harassment. So as most employers in California know, we can't discriminate or harass against our employees. Well, this amends the Fair Employment and Housing Act to clarify that volunteers or unpaid interns are also protected from discrimination and harassment. Okay, so there was some ambiguity about that previously. Now the legislature's made that clear. So if you have an unpaid intern or volunteer, they're going to be considered the same as an employee for purposes of that law. So if they're claimed to be a victim of harassment or discrimination, they're going to fall under those protections as of January 1.
And I could see that, especially for nonprofits where there's a lot of volunteers involved in boards of directors, that sort of thing, that would be very important.
Correct.
Okay.
Good point. Good
Okay.
point. Another big one, AB 2053, harassment prevention training. For several years in California, employers have been required, certain employers, AB 1825 training, which is a sexual harassment prevention training. So that applies to any employer with 50 or more employees, or public entity employers, regardless of the size of the employer. Well, now, as of January 1, if you're an employer subject to that training, you also have to include in that training a component that talks about bullying. Okay. So even though bullying in California is not per se illegal, unless the bullying is specific to a protected characteristic, in your training now, your training will not be legally compliant unless you have a component that speaks to bullying behavior.
I see.
So make sure that if you're undergoing training, particularly near the start of this year, that you update your materials, that your trainer is aware of that, because you want to make sure you don't undergo that training and find, oops, the training we had is not compliant with the new parts of the law that talks about bullying.
Okay.
Also, SB 218, the so-called ban the box bill. The state of California passed in 2014 the ban the box legislation, which prohibits public employers from asking job applicants about prior convictions of any type, not just felonies. Okay?
Interesting.
So if you're a public employer, we advised our clients, my public agency clients, late last year, effective July 1, look at your job applications and make sure there's not a question on there about past convictions. Okay. The important thing for private employers is, in addition to the state of California, there are a number of cities and other counties and entities which pass similar legislation. So for private entities, if, like a lot of construction companies that I represent, et cetera, they may have contracts and do business with some of these public entities. If you do, a lot of those public entities who passed the ban the box legislation, their ordinances say, if you're a public entity and you do business with us, you contract with us, you also cannot ask that question on your job application. So if you're a public entity who does contracting or business with a public entity, be vigilant, see if they passed one of those pieces of legislation, because if they do, it might say that you as a contractor can't ask those questions. So beware of the ban the box legislation. Okay, and it's going to happen in more of the entities, and I suspect it may happen. The legislature may ultimately pass that legislation for private entities. So beware of that.
Okay.
We have time for more?
Oh, yeah.
Okay.
Go ahead.
All right, let's keep going. AB 1660, driver's license discrimination. This is also a big one a lot of people are talking about.
Right.
As I'm sure a lot of Californians know, the legislature passed a bill which talked about now a undocumented person can get a driver's license in California. AB 1660 makes it illegal to discriminate as an employer against a undocumented worker who has a driver's license. So what does this mean for employers? Well, if an employer requires a worker to present a driver's license to them when they find out on that driver's license, oh, I have an undocumented worker, you got to separate that knowledge, and you can't discriminate against that employee. What does that mean? It means as an employer, I can't take that knowledge and go down to INS and report them and say, hey, I have an undocumented worker here. Can't do that. That's discrimination, believe it or not. Okay. Also, you cannot require an employee to present a driver's license to you unless it's required as part of their job.
I see. So if they're required to drive, they have to have a valid driver's license
Correct.
and insurance, but otherwise, no.
Nope.
Okay.
Okay. AB 2536, time off for emergency duty. We've always had in California a law which prevents discrimination by employers against employees who take time off to serve as a volunteer firefighter, volunteer police officer, or rescue personnel. Now we have AB 2536, which actually expands and defines what rescue personnel is. It's an officer, employee, or member of a disaster medical response entity sponsored or requested by the state. Okay, who does that apply to? All employers in California are prevented from discriminating against any employee who takes time off for that. Also, an employer in California who has 50, again, 50 or more employees is required to give a leave of absence, unpaid leave of absence of reasonable duration to those employees.
Okay.
Finally, AB 1723, waiting time penalties. Employees in California have always been entitled to receive their final wages within 72 hours of resigning their employment or immediately upon termination of their employment. And the Labor Commissioner has always been entitled to go after those penalties. This new bill doesn't create new penalties, but it does give the Labor Commissioner new ways to enforce those penalties. So when an employee goes to the Labor Commissioner and says, hey, I wasn't paid appropriately with my final wages or overtime wages or meal and rest breaks, the Labor Commissioner would help the employee go pursue those waiting time penalties. Now, under this bill, the Labor Commissioner can actually cite those waiting time penalties in their complaint against the employer, and it simply gives the Labor Commissioner new avenues to try and enforce those penalties. So more tentacles for the government and Labor Commissioner to go after employers.
Okay.
Okay.
So that's what we're taking a look at for 2015. Now, as a small business owner that may not be up to speed on all these laws and all these changes, how would you recommend that an employer become educated?
Well, there are several ways. One, Cal Chamber, of which Bakersfield Chamber is a
That's
member,
right.
has a great website which is accessible to California employers. They do a good job of updating employers on new legislation, whether it be pending legislation, bills that are in process, or laws that have passed. Okay. There are Bakersfield Chamber of Commerce puts on quarterly employment seminars at the Bakersfield Chamber, whether it be new legislation or whether it be what I call hot button issues.
The next one is Tuesday.
There you go. So that's a good source. There's a local chapter of the Society for Human Resources Management, SHRM. We put on monthly seminars specifically for HR and small employers regarding employment law, employment-related issues. They're monthly at the Petroleum Club. We have a website which is plugged into the California SHRM, which does the same thing. There are a number of good resources for small employers and local employers to find these issues out. But it's important not to stick your head in the sand to keep abreast of these issues. Otherwise, I have a lot of clients who say, I never learned about this until I got sued. Well, that's too late. You need to stay abreast
Ignorance
of
of
these
the law
issues.
is not valid.
And it's not a defense.
Okay.
Yeah.
Well, Jerry Pearson from Young Wooldridge, thanks very much for taking the time to educate us about these new laws. As we mentioned, our labor law employment seminar is tomorrow, and we'll talk more about that. And the employer posters, we do sell those at the chamber as well.
Best place to get
we
them.
try to keep everybody up to speed. So thanks very much for joining us this
You're
morning.
welcome.
All right, we'll take a break, and we'll be right back with more Strictly Business right after this.
If your doctor